Hello, my name is Jamaal Jones, and thank you for tuning into my YouTube page. I'm the principal attorney for Jones Health Law, and we're located in Miami, Florida. And regularly I post videos on interesting topics relating to healthcare professionals. Today's topic, we're going to discuss Florida's Senate Bill 8A's effect on physicians' medical marijuana practices. Recently, Senate Bill 8A was signed into law by Florida Governor Rick Scott that stipulated some of the various different regulations and rules surrounding the medical marijuana industry throughout the state of Florida. I decided that it would be useful and worthwhile to pick the sections that related to physicians, healthcare providers, and just kind of discuss that at length. President Trump has not taken a firm stance publicly in favor of or opposed to the use of medical marijuana. Currently, he intends to leave the medical marijuana issue up to the individual states, Florida being one of those states as well. The 2016 fiscal year omnibus appropriations bill appears to be in line with Trump as it contains language prohibiting the Department of Justice from meddling in state medical marijuana laws. According to the Department of Health report, the state registry now has 16,614 patients. I really expect that number to climb over the years to come as the proliferation of medical marijuana and treatment accelerates. I think that in a few years, there will be well over 500,000 people that will be receiving medical marijuana in some way, shape, or form. A recent state revenue impact study projects that by 2022, there will be approximately 472,000 medical marijuana patients and $542 million in sales, and that's just in the state of Florida. Many activists expect that there will be several lawsuits related to Senate Bill 8A. Legislators anticipated this and have added language that divides Senate Bill 8A so that if certain portions are held unconstitutional, the court would only invalidate those parts without invalidating the entire law. Now, for qualified physicians, under Senate Bill 8A, a qualified physician is a person who holds an active and unrestricted license to practice medicine in compliance with the physician education requirements. In order to be approved as a qualified physician, the physician must successfully complete a 2-hour course, an exam by either the Florida Medical Association or the Florida Osteopathic Medical Association. The exam will cost no more than $500. This requirement also applies to those seeking to become medical directors in medical marijuana treatment centers. Now, what is a medical marijuana treatment center, you ask? A medical marijuana treatment center means an entity that acquires, cultivates, possesses, processes, including development of related products such as food, tinctures, aerosols, oils, or ointments. They may also transfer, transport, sell, distribute, dispense, or administer marijuana, products containing marijuana, related supplies, or educational materials for qualifying patients or their caregivers, and is registered by the department. So, as you can see, the definition of an MMTC, a medical marijuana treatment center, is very broad and includes virtually every type of business within the medical marijuana industry. So whether you're a grower, a distributor, a retailer, providing the marijuana to the patients, or you're providing the devices that they use for the marijuana, or if you're even transporting the marijuana, that all falls under the medical marijuana treatment center definition. So regardless of the structure that you're in, there may not be a structure at all. You still qualify as a medical marijuana treatment center, so don't let the word center throw you off. A qualified physician may not be employed by or have a direct or indirect economic interest in a medical marijuana treatment center or a marijuana testing laboratory. In other words, if you go through the training, the 2-hour course, you pass the exam, you are essentially prohibited from owning any interest, whether directly or indirectly, in any of the types of businesses that service the medical marijuana industry. And it's important to note that they say indirectly as well. I would assume that if you, let's say, are a part owner or you own some stock or shares of stock, if that's even permissible, and they just happen to have ownership interest in medical marijuana treatment center, then that's an indirect ownership of it as well, and that's prohibited under the law. The sentence is important because it means that not every physician is bound by this rule. As I just said, if you're a physician and you have not taken a course and exam to become certified so that you can certify marijuana to your terminally ill patients, then the law doesn't apply to you. For example, if you're a dermatologist who does not treat any terminally ill patients and you're not a qualified physician for purposes of providing marijuana to terminally ill patients, then you're not prohibited from being employed by or having an economic interest in an MMTC or marijuana marijuana testing laboratory. And MTL, or an independent testing laboratory, means a laboratory including the managers, employees, or contractors of the laboratory, which has no direct or indirect interest in a dispensing organization. The aforementioned provision of Senate Bill 8A places broad limits on the types of marijuana facilities and businesses that a qualified physician is permitted to have a financial interest in. MMTCs and MTLs are off limits to qualified providers. We've already determined that. Non-qualified providers are thus able to work for or have a financial interest in medical marijuana retailers, medical marijuana delivery devices, and medical marijuana delivery companies, to name a few. A qualified physician may not authorize a patient to receive more than a 70-day supply limit of marijuana. However, a physician may request an exception to the daily dose amount limit electronically. Further, a physician must evaluate an existing patient at least once every 30 weeks prior to issuing a new physician certification. Now, let's turn our attention to physician certification. Physician certifications mean that a physician may authorize a qualified patient to receive marijuana and a marijuana delivery device, such as a vape pen, from an MMTC, a medical marijuana treatment center. A physician may certify that a patient is in need of medical marijuana only after she has demonstrated the following things, or has participated in the following things. 1, conducted a physician examination while physically present in the same room as that patient and recorded a full assessment of the medical history of the patient. In other words, this eliminates the use of telemedicine to examine a patient for purposes of certifying that they are eligible to receive medical marijuana. Second, you have to diagnose the patient with at least one qualifying medical condition. At this point, that medical condition has to be one of a terminal illness. Determine that the use of medical marijuana would likely outweigh the potential health risks for the patient, and it is documented as such in the patient's medical record. If a patient is under 18 years old, a second physician must concur with this determination, and it too must be documented in the patient's medical record. Fourth, it must be determined that if it is determined that the patient is pregnant, the pregnant patient may only receive low THC cannabis. Fifth, after reviewing the patient's controlled drug prescription history in the prescription drug monitoring program database, and there's a determination that the patient is not abusing it in any way, then the physician can then certify the patient to receive medical marijuana. After the physician has reviewed the medical marijuana use registry and confirmed that the patient is not currently receiving medical marijuana from another qualified physician, then that physician can certify the patient to receive medical marijuana. Also, the physician has to register as the issuer of the certification to the patient on the medical marijuana use registry. And finally, the physician has to obtain the voluntary and written consent of the patient or their parent or guardian, if they are a minor, only after the physician has sufficiently explained its content for the medical use of marijuana each time the physician issues a certification to the patient. A physician certifying the use of medical marijuana for their patient must use standardized informed consent forms adopted by the Board of Medicine or the Board of Osteopathic Medicine, which must include at a minimum the following. 1. The federal government's classification of marijuana as a Schedule I controlled substance. 2. The approval and oversight status of marijuana by the Food and Drug Administration. 3. The current state of research on the efficacy of marijuana to treat the qualifying conditions. 4th, the potential for addiction. 5th, the potential effect that marijuana may have on a patient's coordination, motor skills, and cognition, including a warning against operating heavy machinery, operating motor vehicles, or engaging in activities that require a person to be alert or respond quickly. 6th, the potential side effects of marijuana use. 7, the risks, benefits, and drug interactions of marijuana. That the patient's de-identified health information contained in the physician certification and medical marijuana use registry may be used for research purposes. That's number 8. Now, I'm sure you must be asking yourself, well, what is medical marijuana use registry? I've mentioned it a few times, so let me kind of elaborate a little bit on what that is. Physicians should be aware that a review panel will be created by the respective boards to review all physician certifications submitted to the medical marijuana use registry. The panel will track and report the number of physician certifications and the qualifying medical conditions, dosage, supply amount, and the form of marijuana certified. The panel will report the data by individual physician and in aggregate formats by county and statewide. On the surface, it appears that the board is just collecting data from those who certify patients to receive medical marijuana. However, it also appears that the board is analyzing patterns and potential abuse by physicians who overprescribe or prescribe at a much higher rate than other qualified physicians that are similarly situated. At this time, I'm not sure what action the board would take, if any, if they determine that there is some irregularity with the prescribing pattern of a particular physician. Just be aware of your prescribing patterns. The medical marijuana use registry must be accessible to qualified physicians and MMTCs to verify the authorization of a qualified patient or caregiver to possess marijuana or a marijuana delivery device and record the marijuana or marijuana delivery device dispensed. The goal of the registry is to prevent an active registration of a patient by multiple physicians who can then receive and possess an amount of marijuana that exceeds the legal limits. The fear is that this will lead to an abuse of the Schedule I drug. Now, finally, let's quickly talk about some of the penalties. Senate Bill 88 doesn't contain many penalties for physicians apart from the other laws and board rules that currently exist to which physicians are bound by. However, I'm confident that with the proliferation of medical marijuana used by terminal patients and the tracking of prescribing patterns by the board, that there will be additional penalties for physician owners and qualified physicians on the horizon. A qualified physician who issues a physician certification for marijuana or a marijuana delivery device and receives compensation from an MMTC related to the issuance of the physician certification for marijuana or a marijuana delivery device is subject to disciplinary action under the applicable Practice Act at Florida Statute 456.0721M. So that's all that I have for today with regards to medical marijuana and how it may affect physician practices. Thank you for taking the time again to look at my video. If you have any questions about this or anything else related to healthcare law, please contact me. You can visit our website at www.joneshealthlaw.com. You can email me at jrj@joneshealthlaw.com. You can follow me on Instagram at joneshealthlaw.com. Connect with me on LinkedIn. Again, my name is Jamaal Jones. Or you can subscribe to this YouTube page. Thank you very much.